Good morning, everybody. My name is Margaret Hinkle. I chair the Post Commission. Welcome to members of the public who are in attendance today. We're grateful for the fact that you're interested in what we are doing. Let me begin with a roll call of those commissioners in attendance. Commissioner Baker,
Present. Good morning.
Commissioner Calderon,
Here, good morning, all.
Commissioner Crispin,
Good morning. I'm here.
Commissioner Hall,
Good morning, present.
Commissioner Kazarosian,
Good morning, President.
Commissioner Luma,
Good morning, President.
and Commissioner Talley.
Morning, present.
We are missing Commissioner Bluestone today. She's unable to be with us. We do have a quorum in attendance. I would at this point ask for a motion to approve the minutes of our last meeting. Is there such a motion?
So moved.
So moved.
Is there a second?
Second.
Thank you. I think Commissioner Baker seconded that, but Commissioner Baker, if not, do you approve?
I second it and I approve.
Thank you. Commissioner Crispin,
Yes.
Commissioner Hall,
Yes.
Commissioner Kazarosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley.
Yes.
And I also approve. So the minutes are approved. Let me turn now to the Executive Director report, please. Enrique?
Thank you, Madam Chair, and good morning, Commissioners. I will ask Jamie to share her screen. I will update you with a brief slide deck. As a reminder to those in attendance, the Commission does not take public comment at its public meetings, but we ask members of the public to reach us by using any of the resources in the screen. That is, send us an email at postc-comments@mass.gov or call the number 617-701-8401. We accept and very much appreciate every time you send us comments, and we make sure that they get to the appropriate person. Okay, next slide. So this slide represents the certification numbers since I last reported them at the June meeting. As you can see, we have ascertained the final number of certifications expiring on June 30th to be 4,978 individuals. The difference from what we have ascertained in the final numbers of certifications last time are really those individuals who may have retired or left an agency since, within last year. As I mentioned, these are mostly simply retirements, and in individual agencies not always timely report those individuals leaving law enforcement. Again, this recertification process serves as the ultimate corroboration of ensuring that our records are up to date. I want to highlight a figure that tells the story of the workload of the Division of Certification over the past few weeks, and that is the 2,080 applications or BLAs that were submitted since June 15, just 15 days prior to the deadline. Well, we were expecting initially 2,242 applications that were, again, our expectation last time. The final number came in lower. We received at 2,080. And it's also important that the Division of Certification corroborate that all those officers, that difference of officers, are indeed reconciled and updated with our records, as I just said a minute ago. So this is an ongoing, involved process. It requires some communicating with agencies, because the reality is that we deal with all 433 agencies when it comes, mostly all of these agencies when it comes to this process. And that means the certification team has been working really hard to ensure that those applications get processed timely. We have also received all the attestations of the chiefs that fall within this category of I through P or expiring this time frame. And I will also mention that the last days of the deadlines required the outreach to the agencies to submit and corroborate that information. So I just want to say a job well done by Stephen Smith and everyone at the Division of Certification. Let's go to the next slide. Just a couple of notes here on the next steps for the certification cycle. The division will be processing and sending the certification notices. As a reminder, every time, as long as agencies submit the certification application or BLA in a timely manner, the individual officers remain certified. But the notices don't go right away. There's a quality assurance process. We ensure that that the dates and the addresses are correct. And even though we've sent as of last week, we had sent 1,984 notices. We still have about 2,984 of them to be processed, or ultimately their notice to be sent. That notice is a letter that constitutes the certification for the individual. And as a reminder, many of these notices have a duration of 3 years plus the number of days or months that it takes to get to the officer's birth month, so that we continue to streamline all of these certification expiration dates to the time that the officer has a birth date within that month. Just of note, of the 1,994 notices sent, the vast majority, which is very common, are certified. Only a handful are conditionally certified, and that is 34 at this point. Many of those conditionally certified individuals happen to be those individuals who went to the Breach Academy, might have gone to the Breach Academy, and they still have until December 1st of 2027 to complete the work hour requirements. Only 3 certified SROs, but of course, all of those numbers will increase as we continue to process those BLAs and send out those notices. Let me ask to go to the next slide, please. Just another brief update on the effort by the group of people, the joint group of MPTC personnel and post personnel who's been working on the use of force model policy. As of last time, we had 2 sessions that the commission that the team had given when it comes to those sessions. The last session was in Randall just a few days ago. It was also recorded and available and will be made available to all law enforcement agencies via the CADIS systems. There were some questions in the first 2 sessions. There were less questions in the third session, perhaps because it was being recorded, but otherwise, good questions regarding compliance, the use of force reports, and what will be required to be submitted to post. Matt Landry and Jerry Cahill will be talking a little bit more about what we have in store via regulation revisions later in the meeting. But a lot of those questions, very much what we typically get, and it's important that we always clarify them and are happy to get those questions. It means they're interested in making sure that they're in compliance. There's other questions about applicability, whether certain this model policy will apply to not certified personnel who may be engaging in a similar type behavior. We will come back at a future meeting after we ascertain more about those job functions with future recommendations to the commission and future positions as to how we answer that applicability. Of course, at the moment, everybody who is certified and is required to be certified must comply with the use of force model policy as per the regulations. Next slide. And I think that at this point, you can stop sharing, Jamie, and I can turn it over to the chair if there's any questions or comments from your commissioners.
Don't think I see any hands in the air. Thank you very much, Enrique, and those who have worked with you on the matters that you've addressed. Let me move on to item number 4 on our agenda, the finance and administrative update. Turn it over to Eric, please.
Thank you, Madam Chair. Just one moment. I'm going to share my screen. Okay. All right. I'll start with FY26 activity. Depending on final activity during the accounts payable period, which we're in right now, we are estimating year-end total spending to be approximately $8.48 million. The Q4 memo is included in your packets. It also includes the Q4 Treasurer's Report and the year-end org chart. We are expecting a reversion of about $425,000. This is higher than our last reported projection of $300,000. We had a few IT items that did not come to fruition at the end of the fiscal year in terms of prepayment. And as of June 30th, we were only one position short of the 55 employee target. So we are now at a head count of 54. For human resources, Brian Park is the 5th legal intern to join the legal division. He comes to us from Boston College Law School, so we do extend to him a nice warm welcome. And at this time, there are no open or posted positions. However, we do intend to be posting soon for positions to fulfill our audit mission. For FY27, much has occurred since our last meeting, which was in June. The conference committee released the final budget with post appropriations set at $8.83 million. The conference committee preferred the lower of the 2 appropriations that they were given between the House and Senate. Nevertheless, we are confident this number is manageable, especially if we continue to utilize operational efficiencies as we've been doing. The next step in the budget cycle process is the development of spending plans, which we have already begun with our kickoff, which began on June 23rd. And then finally, we wanted to provide you with an update as it's been 6 months since we reported the Commission's diversity metrics. As you can see, we compared post metrics to the makeup of the state's population and the over 45,000 state employees. A detailed memo was included in your packets. And as always, of course, we will continue to regularly review these statistics and report them back to you. So the next report will be in January. And that concludes my report, Madam Chair.
Thank you very much, Eric, and those who have worked with you. I don't think I see any hands in the air, so we'll move on now to the legal update. And let me turn this to our General Counsel, Randy Ravitz, please.
Thank you, Madam Chair. I will first turn the floor over to Division of Police Standards Director Matthew Landry and Legal Division Counsel Jerry Cahill, who will discuss the development of a draft set of revised regulations governing the handling of complaints by law enforcement agencies and our agency, which is the product of a great deal of careful thought by them and incorporates feedback provided over time by people inside and outside our agency. Matt?
All right, good morning. Thank you, Randy, and good morning, commissioners. I will turn this over to Attorney Cahill in just a moment, but before doing that, I wanted to briefly explain some of the overarching policy goals that have led us to draft these proposed regulatory updates to 555 CMR 1.01. So you may remember that I presented on the topic of so-called minor complaints last August at the public meeting. At that time, I proposed that we consider updating CMR 1.01, and I identified 2 main areas for attention. First, we recommended updating the definition of minor complaints in a way that more clearly reflects post's priorities. This would help us prioritize those complaints that squarely fall within our agency's mission as defined in our enabling statute. Second, we recommended developing a more efficient process for supervising investigations concerning certain minor complaints. Our agency's enabling statute specifically allows us to create a streamlined process for the handling of minor complaints. And given the huge volume of complaints that we do receive and review, that's something that we want to take advantage of. I believe the draft that we're going to present today accomplishes both of those objectives. First and most significantly, we've proposed a list of 22 serious violations of law enforcement standards. This is a list that we took directly from various provisions of Chapter 6E and other applicable laws and regulations. The list represents a concrete list of the kinds of allegations that our agency was specifically tasked with focusing on. I should point out that this list is in very large part taken from a list that already exists. It's contained in sub-regulatory guidance, which the Commission previously adopted in September of 2023. So this list really reflects, it's in large part that list with some modifications. Next, and as Attorney Cahill will discuss in more detail, we propose to classify, basically, we'll have the 22 so-called serious violations, and we would define everything else as minor, which is sort of the reverse of the current process. We would propose to further subdivide minor complaints into those complaints that can still be handled at the agency level without post-involvement, and also specify categories of minor complaints that would need to be reported to post under a streamlined process that maintains full accountability and transparency of the agency's investigation, but also achieves administrative efficiencies for the Commission by reducing the number of touch points between posts and the agency during the investigation itself. That would be for certain categories of minor complaints. We'll explain this in more detail soon. In short, this draft makes a serious effort to define the various types of complaints that our agency receives, prioritize them, and to lay the groundwork for a successful agency audit program, which, as Eric just mentioned, is a goal of our agencies for the present fiscal year. I should note the draft also makes numerous other improvements if adopted. Among them, we're proposing to codify when agencies can deem a complaint to be non-credible. We are proposing to fix a 60-day deadline for agencies to impose discipline following sustained internal affairs charges. Currently, there is no deadline. And we've updated some language about the processes for actually doing internal affairs investigations that mainly reflect best practices that we've seen across the profession during the last several years. Above all, this draft is the product of a team effort. I want to thank the members of the legal team, especially, who supported us by drafting this update. And I also want to thank the members of the standards team who took the time to provide input and review on this draft. That being said, this is, of course, a first draft, and so we are very much looking forward to reviewing and incorporating feedback from the Commission, members of the public, and the profession. And with that, I will hand the floor to Attorney Cahill. Thank you very much.
Great. Thank you, Matt, and thank you, Randy, too. And thank you as well to the many members of the post-commission staff who've had a hand in shaping the draft that we've submitted to the Commission for your consideration. That draft contains proposed revisions, as Matt just was describing, involving minor matters. And I'd like to share with you now some of what is contained in that draft. And to be clear, again, as Matt just mentioned, we're not asking for a vote today. We've submitted the draft to you at this point in the process so that we might get suggestions and feedback from you and from members of the public. If I may share my screen. Okay. Can you see that?
Yes.
Great. So for the benefit of the public, let me start with a brief description of the regulations as they now stand regarding minor matters. Currently in our regulations, we have two categories of complaints, minor complaints and non-minor complaints. Now, non-minor complaints are reportable to post within 2 business days of receipt. And what is included in the category of a non-minor complaint? Well, a non-minor complaint is any complaint containing allegations of misconduct for something that is not a minor matter. And we'll talk more about what is a minor matter in just a moment. Now, minor complaints are not reportable to post. And what is included in the term minor complaints? Well, as you all well know, minor complaints are complaints that contain allegations of misconduct solely involving minor matters. And minor matters, as currently described in our regulations, is a category that includes discourtesy and basic work rule violations, such as tardiness, inattention to detail, equipment violations, grooming violations, or comparable infractions. And the complaint does not involve evidence or an allegation of bias, excessive, prohibited, or deadly force, or an action which resulted in serious bodily injury or death. That is what is included now in the term minor matters. So currently, agencies do not have to report minor complaints to the Post Commission, and agencies do have to report non-minor complaints to Post. That's where things stand now. Now, over the years, agencies have said that they might benefit from additional elaboration on the line between minor and non-minor complaints. And we've taken their feedback to heart. I'd like to show you how we are proposing to provide additional elaboration on that line between minor and non-minor matters. Now, in the proposed revisions, we've recommended providing more guidance for what a non-minor complaint is by affirmatively describing the qualities of a non-minor complaint. And as Matt and Randy just mentioned a moment ago, this is in large part incorporating what has already been improved through guidance by the Commission. But let me explain more in detail what that is. So we've sought to describe the qualities of a non-minor complaint through a description of what amounts to a serious violation of law enforcement standards. Now, in the draft of the proposed revisions that you have before you now, a complaint that contains allegations of a serious violation of law enforcement standards is treated much like the non-minor complaints that we currently have. For these types of complaints involving allegations of a serious violation of law enforcement standards, just like with the non-minor complaints, an agency must report such a complaint within 2 business days of the agency's receiving the complaint. Now, what is included in a complaint alleging a serious violation of law enforcement standards? This is what Matt and Randy were talking about just a moment ago. It's a defined list of specific types of officer misconduct. There's 22 of them in all. And that list is derived from Chapter 6E, other relevant statutes, and priorities as defined by the Commission. Now, the following are some examples of what we propose should be considered as serious violations of law enforcement standards. Those examples include officer misconduct involving excessive force, biased police conduct, criminal offenses, any other statutory bases for a preliminary inquiry, suspension, or discipline by post, and the list goes on. And as you can see in the draft of the proposed regulations that we have submitted to you, where we affirmatively describe what types of misconduct would make an allegation fall into the category of serious violation of law enforcement standards. Now, let me be clear. Complaints involving a serious violation of law enforcement standards would have the same 2-day period for reporting to the Commission that non-minor complaints have. But we are now proposing specific categories of conduct that would trigger those expedited reporting requirements. We think that such a refinement in our regulations will help the agencies that must report those complaints to post. Now, as for minor complaints, that's to say complaints involving solely minor matters, the draft of the proposed regulation has split those types of complaints into 2 separate categories, as Matt just mentioned a moment ago. There's minor complaints that must be reported to post and minor complaints that do not have to be reported to post. Now, for the minor matters complaints that must be reported to post, they don't have to be reported within 2 business days after the agency's, but only after the agency's completion of their internal investigations. These are minor complaints, after all. There is not as great an urgency for the Post Commission to be speedily informed of these complaints. And Chapter 6E, Section 8B1, specifically authorizes the Commission to establish a streamlined process for the reporting and handling of such minor complaints. And that's what we propose doing here. And what types of minor complaints under the proposed revisions must be reported to post? Well, complaints alleging conduct unbecoming an officer, complaints that concern the officer's conduct during their interaction with the public, except where there are allegations only of rudeness or discourteousness, complaints alleging that an officer violated the agency's body-worn camera policy, and situations where the Division of Standards orders the agency to investigate the matter. So for those types of minor complaints, we are proposing that the agency report those matters to post, but not as quickly as an agency would report allegations involving a serious violation of law enforcement standards. Agencies would have to report such minor matters only after the agency's completion of their internal affairs investigation, not within 2 business days. Now, just as before, under the proposed revisions to our regulations, there also would be minor complaints that an agency does not have to report to post at all. Those are the complaints that do not allege a serious violation of law enforcement standards and also do not fall into the categories of minor complaints mentioned just a moment ago that would require a reporting to post. Now, some examples of minor complaints that would not have to be reported to post include an internal work rule violation involving, for example, grooming or an officer's uniform, or interactions with the public where the only allegation is that the officer was discourteous. For those types of complaints, an agency still, under the proposed revisions, would not have to submit a report to post, just as they do not have to submit a report today for such complaints. So those are some of the refinements to the regulations that we are proposing to you today regarding what would qualify as a minor and non-minor matter and the reporting requirements for each of those matters. These proposals are based on feedback that we've received from agencies, on the experience of the post-commission staff in our handling of the intake of these complaints, and on an analysis of what types of complaints would be in the public's best interest for the post-commission to receive. Now, allow me to switch gears for just a moment. I'd like to share with you some refinements we are proposing regarding the definition of credibility within our regulations. Currently, as you know, the regulations provide that an agency must first have a complaint to trigger the requirements regarding reporting of that complaint to post. But what is a complaint? Our current regulations state that a complaint, among other things, must be credible. If it's not credible, it's not a complaint. And if it's not a complaint, then it doesn't trigger the reporting requirements for complaints currently in our regulations. So what amounts to credible or not credible in this context is important. The current regulations do not define credibility. In the drafts before you today, we have proposed a definition and explanation of credibility for the purposes of this section of the regulations. That definition and explanation states that every complaint shall be initially presumed to be credible, and that a complaint may be deemed non-credible by an agency only if the agency establishes through an initial exercise of due diligence that the material, factual allegations of the complaint are clearly and demonstrably false, that the material, factual allegations of the complaint are based entirely on speculation or conjecture, that the complaint is made anonymously and provides no adequate basis for investigation, or that the complaint fails to allege conduct that would violate Chapter 6E, 555 CMR, or an agency's rules, regulations, or policies. In any of those situations, an agency would not have to report the complaint to post because the complaint will not be deemed to be credible, as that term is defined in the proposed regulations. Now, much of what these proposed regulations do as it relates to credibility is to put into words what we believe that many, if not most agencies already do in their determinations of credibility regarding the complaints that they receive. But since credibility is an important issue as it relates to the reporting of complaints to post, we thought it would be helpful to provide further guidance in this part of the regulations on what types of analysis an agency should engage in and what sorts of considerations an agency should weigh when that agency is making its determinations regarding the credibility of a complaint. Now, I'd like to discuss one more change that we are proposing in the draft of the regulations you have now before you. The issue involves what constitutes formal discipline. Now, this definition is important because it involves what kinds of discipline would be reported to post for certain minor matters. To be clear, what we are talking about now does not affect the reporting of discipline for a serious violation of law enforcement standards. Any type of discipline, no matter what that discipline is, formal discipline or not formal discipline, still should have to be reported to post for a serious violation of law enforcement standards. The same is true for allegations of reportable minor matters. For example, an allegation of conduct unbecoming or complaints involving interactions with the public. For those types of complaints, an agency would still have to report to post the discipline that the agency imposed, no matter what that discipline might be, formal discipline or not formal discipline. But then we get to the other types of minor matters, the non-reportable minor matters. In the proposed revisions to our regulations, would an agency have to report the discipline imposed in those situations? The answer to that is yes, if the agency imposes formal discipline, and no, if the agency does not impose formal discipline. In this way, if a certain level of discipline is imposed upon an officer, post will be informed of what has happened. The discipline itself and the seriousness of that discipline will trigger the reporting requirements for those minor matters, for even those minor matters that would not otherwise be reportable to us. So when we talk about the seriousness of the discipline, what under the proposed revisions is considered serious enough to warrant such reporting? Well, anything that amounts to formal discipline. And more specifically, formal discipline includes terminating employment, entering into a separation agreement, issuing a suspension, requiring retraining, demoting the officer, requiring the officer to forfeit time off, modifying a duty schedule, or entering into a last chance agreement or an agreement to defer, forego, or limit a more serious form of discipline. And such formal discipline would not include the following: a written or oral reprimand, job counseling, supervisor coaching, or a referral for treatment by a medical or mental health provider. Let me give you an example. If an agency gave an officer a written or oral reprimand for, say, a grooming violation, the agency would not have to report that to post. The issue, the grooming violation, is a non-reportable minor matter, and the discipline, oral or written reprimand, is not formal discipline. On the other hand, if an agency suspended an officer or terminated the employment of an officer for a grooming violation, the agency would have to notify post of the discipline. The discipline itself would trigger the reporting requirement for such a case. But why require such cases to be reported at all? Because the level of discipline suggests that something more serious may be involved here than in an ordinary minor complaint. And it also allows our agency internally to identify potentially problematic or inequitable trends in the imposition of discipline. On the other hand, why then wouldn't we require all minor complaints to be reported, even if there is no formal discipline? Because there would be little, if any, benefit to the public from post's involvement in a case that involves such truly minor matters. And the streamlining of the process for these types of minor complaints will enable the Commission both to increase administrative efficiencies and to focus our work on the most serious of complaints. So we've created the category of formal discipline to inform the Commission of minor matters that may warrant our attention and to allow the agencies to deal with matters internally and without reporting to post, when reporting such information to post would not realistically provide any benefit to the public. Now, there's one further issue that I'd like to address before I conclude. The proposed regulations here would require agencies, especially for some types of minor matters, to report additional information to post. For example, a non-reportable minor matter, such as a grooming violation, where the agency has imposed formal discipline. The fact that the Commission would receive such information does not necessarily mean that the Commission would publish such information in our public disciplinary database. Our intent here with these proposed regulations is not to publish the smallest things about people or to expand the scope of the public database. We recognize the changes here in the portion of our regulations that deal with the reporting of minor matters may require us to adjust the portions of our regulations that deal with what information is published in our public records database. We recognize that, and we plan to address that issue separately at a later time. As I mentioned earlier on, the draft of the proposed revisions that we have submitted to you today are, of course, merely proposals. We very much welcome any input that you might have about them so that we can improve this draft with the benefit of your thoughts and feedback. And we also, as always, welcome comments and suggestions from law enforcement and members of the public. You can submit your comments and suggestions to postc-comments@mass.gov. We review every submission carefully, and we very much welcome yours. Thank you all for your attention today, and with the chair's permission, I'd be glad to address any comments or questions that you might have.
Jerry, I think Commissioner Luma has a question.
Oh yeah, please, yeah.
I do. Thank you so much for your presentation. There's a line that I'm hoping that you can either expand upon or clarify for me. In the section where I don't know if you can put the slide up, but it's it says yes upon completion of an agency's IA as far as being reportable, and it says any interaction with the public except rudeness or discourtesy.
Sure.
That seems a bit broad to me as far as the any interaction section. Can you talk a little bit about that and what do you mean by that?
Sure. Yeah. Would you like me to put up the slide or try?
Sure.
Okay. Let me see if I can do that.
It's the minor complaints category.
Yes.
Yes.
This one right here?
Yes.
Great. Yeah. So, thank you for raising this. And like so many things in this proposed regulation, this was an effort to strike a balance between, what would be helpful for the public and for Post, information that we felt would be most helpful for the public and Post for us to receive, and what would and the public's interest in having us receive this information. So there's a sense that when it comes to interactions with the public, that these are typically sufficiently important for us to have some sense of any complaints involving the public, and that's why there is a carve out up above in the complaints to be reported to us, because, like you said, these interactions cover a lot of grounds. They can have a lot of different sort of facets to them. So we wanted to really get a sense of what happened in those. We thought that was important, and yet when the only thing that was really at issue was rudeness or discourteousness, we thought that those were minor enough that there wouldn't be as much a benefit for us to have that information and for the offices, that the agencies to share that information. But that's a balance that we struck. But I'd be interested to hear your comments and thoughts about whether you think that balance is the right one.
No, that was very helpful. It provided perspective. So I actually appreciate that carve out was made. So thank you for that.
No, thank you. Thank you for raising it.
Commissioner Calderon.
Thank you, Madam Chair. Jerry, if I could ask you to bring that screen back up, I had a few questions myself.
Yeah, of course.
Taking some notes on that particular screen. First, what is the benefit? Sorry, I'll let you bring that up first.
Sorry. Is it a?
No worries.
Great. Can you see that now?
Yes, I can.
Okay. Yeah, thank you. Yeah.
So in reporting and making sure I understand it correctly, in the second box down, minor complaints is where I am. Body-worn camera violations. So we have such a large department in Boston, right? 2,100 offices. And right now, the current policy by the Boston Police Commissioner is if you're in a violation of a body-worn camera policy, that you receive a 1-day suspension. I guess, what is the significance of the commission spending the man hours and the personnel hours creating data on somebody forgetting to turn their body-worn camera on or the camera malfunctioning? As we all know, it buffers all the time. So there are times that you double-click to turn it on. I fail to see where the significance is or why it would burden the commission with reporting a body-worn camera 1-day suspension or reprimand.
Yeah, no, and thank you for bringing that up and for your perspectives on that. That's why we present these issues to you. I think I think that the thought behind that was, first of all, it has to be a violation of a body-worn camera policy, not just something happened that's not a violation. So I think that is one thing that we should consider. And I think that the sense here was, again, trying to strike a balance between things that are it would be helpful possibly for us to know, and things that might not be helpful for us to know. And if there's, I think the sense was that if there's an interaction, especially with the public, where the body-worn camera was not turned on because of a violation, not some other reason, then that might be helpful to know, in the sense that, well, is this a one-off thing? Is this a pattern? It'd be what was not recorded there. Those are all questions that might raise red flags, but they might not. And that's part of the reason why we thought that it would be helpful to have that in the minor complaints section, where we're not asking for this right away, or be after the investigation, but that it might be worthwhile for us to have this information come to us. But I hear your perspectives as well, and I really appreciate them, and thank you for raising them.
No problem. I'll put something or submit something in writing to everyone as some opinions on it, because everything, and I'm only speaking again in Boston, I don't know how the Mass State Police or any other organization is working, but in Boston, just not having the camera on is the violation, which I can speak to you from the membership that I represent. It is somewhat overused in Boston. Take last night's shooting. 2 police officers are stopping a car. Their camera should be on. Subject jumps out, fires around through the windshield of the police cruiser. As they're alighting from the vehicle, and foot chase starts, and the camera doesn't activate, or they just simply forget to activate that camera. That's going to be a rule violation. It seems to me that that's something above and beyond the scope or the time wasted by the commission and its employees to create that data and track that information. But I'll submit that on the body-worn camera piece. The next line down.
I'm sorry. And I stopped sharing it. Let me get it back for you.
Sorry, I have a few questions, so I apologize.
Okay. Yeah, I'll keep this up. Yeah. Thank you.
That last line down, when ordered to investigate by the division, could you give me an example of something that the division would order that maybe we're unaware of?
You mean like a past example of where this has happened, or something that might happen in the future?
Well, give me both. Has the division ordered a department to do something that the commissioners are unaware of? And if moving forward you intend to do that, what would be an example of such that the commissioners again wouldn't be aware of?
Sure. I don't know if past examples, maybe someone else would be able to speak to that, but I think that going forward, I think that the sense is that if there's some sort of red flag, even if it were falls into the category of minor complaints that were not reportable to post, something that just doesn't seem like it squarely fits there, then the Division of Standards may, just using their authority under Chapter 6C, they may say, you know what, and now this regulation, they may say, we want to take a closer look at this. Can you please provide us more documentation here? It's a little difficult, I think, to give like a really clear example, because we worked so hard to try and provide the specific examples that we could think of, where we want that information. I think this is more of a catch-all, just to say, hey, we recognize that as hard as we tried and as hard as we worked to try and categorize all the things that we think we might that might raise a red flag for us, or that we might want information for, we recognize that there might be things outside of that as well. And so we like the ability.
Jerry, I have an example. Oh, yeah, go ahead, Matt. I have an example as well.
Please, refer to you, of course.
Well, we have gotten a few of these in the past, Commissioner, and it's likely somebody complains with the agency and they don't get anything, no response, etc. The agency doesn't act on it. They deem it not credible and they don't submit it to post. And then that same person submits a complaint to post. We look at it and we think it's credible. Somebody should look at it. When we contact that agency and they say, well, we didn't think it was credible, we might be in a situation where, given the fact pattern and when they submit it to us, that we find ourselves in the position of ordering the agency to follow up on such a complaint. In other words, we don't know what agencies sometimes are deeming not reportable to post. And in some instances, based on other facts ascertained by the Division of Standards, it could be the case that we think that they should further investigate. That's one example of past instances. We've seen a couple of those, Commissioner. I think it's about having the clarity that we have this role in regulations would be most important.
And if we could, I know that Commissioner Crispin has had his hand in the air too, but let me, at this point, just if you don't mind, Commissioner Crispin, can we turn to the Division of Standards and to Matt, just to see what he wants to say to elaborate on what Enrique did, and then I'll get to you, please. Go ahead, please, Matt.
Thank you, Madam Chair. Enrique said 90% of what I was going to say. The only thing I'll add is sometimes we get a complaint filed with post. We will share that with the agency. And I can think we've thought of hypotheticals, like not real cases, but potential cases where, let's say that when we share a complaint that we're concerned about with the agency and ask for their perspective on it, perhaps they would say, well, that's rudeness or discourtesy. What if we had a concern that there was actually a pattern of bias there? Like, what if it wasn't just rudeness or discourtesy? Maybe it happened 5 times before that, or there could be a reason that we would say to an agency, no, we think you need to look into this. If not, look into it ourselves. So that's a hypothetical. I don't have a real case to point you to, but it's for reasons like that, mainly for what the executive director just said, that we would put in the regulations the ability to tell an agency you need to look into this. I hope that helps.
I appreciate it. The hypothetical is actually what I'm worried about, and I think that belongs within the hands of the commissioners, not the division. But we can go further later because I know that the chair wanted to move on. I'll come back in with a couple of questions after others get to speak. Thank you.
And at this point, Commissioner Crispin, please.
Yeah, so Matt addressed one of the concerns I had around what the level of subjectivity that sometimes takes place in these incidents, right? What the agency labels as discourtesy, right? When you look at it, could be an incident of bias. And again, my concern is always subjectivity and discretion that is allowed to some of these agencies in terms of what they charge and how it results in discipline for different officers. And then in terms of the body-worn camera issue, in terms of officers not turning it on, I think generally, if we look at it as a one-off, yes, maybe agents shouldn't have to report it. But I think there are officers, if there's a clear pattern of continual failure to turn on the body-worn camera, especially in incidents where it results in a complaint against that officer, then I think we probably should take a harder look at that.
Thank you. Enrique?
Yeah, I want to address a little bit the body-worn camera. We are getting those complaints for the most part already, those incidents. We've taken the position that those should be reportable, especially when there is a disciplinary matter, because elsewhere in the statute we're required, as the Commission knows, to maintain a database of disciplinary matters for the public interest, and for the most part we already get those reports, and we post them when they're ready in that database, and therefore we look for trends, etc. And that's other reasons to continue to capture this information. We're just making it more clear.
Thank you. And maybe back to you, Commissioner Calderon. I think you did indicate you had some other questions.
Thank you, Madam Chair. Appreciate that. So I guess in the bigger bubble of this, and I'm not sure who could answer it, as we attempt to put these new regulations in effect, what are the actual consequences with the agencies? Because I know that this has been discussed very thoroughly in our meetings, that at some point in time, the agencies that aren't complying or that are out of compliance, are we creating a consequence for that? Well, we have a case that I know in particular that's 2 years old that wasn't reported on. So things of that nature, embarrassingly enough as it is, are we getting to a portion or a position where we're going to institute some kind of consequence?
Thank you. Enrique, back to you.
Yeah, I think that's the hope. That's a big hope. In addition to clarity, Commissioner, being more precise as to where we're drawing the line, so that everybody can be, can know where they stand. There's also this idea that we're building this database for other reasons where we might be in a position to want to follow up ourselves, and importantly, the clarity around minor matters. And the efficiencies that agencies will realize. Not just Jerry mentioned that this will be efficient for us. I wanted to emphasize that it will also be efficient for agencies. The current state is that they have to submit everything that doesn't look like minor, and that sometimes means 3 touch points with post. First, when the complaint came in, then when the matter is investigated, and then when the matter is resolved. For that category of minor complaints that are reportable, they only have to do it once at the end when the discipline is imparted, and that goes into building our database, and that's important part of our work, etc. But it makes reporting to post a lot easier, frankly. And there's a lot more, in my view, once we educate agencies around this process, and once we have this dialogue that we expect to have, that will make things a lot more efficient for us and the agencies.
Thank you, Mr. Director. The last thing that I had is I had a lot of inquiries from organizations that represent the members out on the street, and I'm under the impression from those conversations that they will submit some concerns and briefs, specifically around the minor matter section. It seems very thoroughly thought out and put together by Mr. Cahill and team, as it's been laid out here. But I think the concern from many of the groups that we'll hear is, although we're saying that minor matters don't need to be reported at certain levels, it's almost every minor matter is actually reported. But I'll leave that to the individual organizations to articulate in writing, but I did want to share that openly.
Yeah, thank you. Thank you for that.
Can I respond to that on this question?
Of course.
We're also clarifying something here around written reprimands. That's something we've heard a lot about agencies as meaning everything gets reportable. By saying oral reprimands, written reprimands, or oral reprimands that are documented, they don't need to be reported if they fall in the category of minor matters. Because our prior position was that once you have a written reprimand that can be used against the officer in a future disciplinary matter, in progressive discipline, that written reprimand needed to be reported. We are now carving out that written reprimand to stay within the division, within the agency. And if it escalates further into for a subsequent incident that now merits a suspension, for example, then that's when it can get reported to post. I believe the written reprimands exception will also make allow agencies to be more efficient and more be able to supervise what they say. Supervisors need to be able to supervise, to talk to people. Now they have to document it all the time, and even though it's documented, it doesn't need to be reported to post.
I understand those, and I think those are well received by the organizations and the memberships as well. I think I think what we're going to hear, or the response would be, Mr. Director, is some of the actions that are required. One being that body-worn camera thing, where again, only in Boston, you're getting a day off for it. That's been what the commission has been instituting. I consider that a minor matter. If 2 officers are chasing somebody that just fired around at their cruiser and they don't double tap their camera, I find that hard to believe that the general public needs to know that they received a day off suspension. And I totally disagree with the Boston Police Commissioner that should be handed down for discipline, but I don't run the department. So, but some of the smaller issues that did come up were the retraining portion, maybe an in-house suspension of getting a day off for a minor matter. Those all need to be reported, and at which point in time does it become overly intrusive, or just a waste of, again, the division's time to to pay people to put that information online to see that somebody got a day off in-house or retraining seems like an awful lot of work and a waste of taxpayer dollars. So anyway, I appreciate the time. Sorry to monopolize a lot of the conversation here, but I had a lot of questions that were posed to me. Thank you.
Thank you. And Commissioner Crispin, back to you, please.
Real brief in terms of oral and written reprimands, I think the issue that most officers have is that oftentimes they're not in a position to appeal that for most agencies. So it's sent to you, you take it, and you have no other alternative to appeal the decision. And I think if over the course maybe of a couple of years, you get a few of those written reprimands, some of which you may have been able to win at an appeal, you don't. And it looks over time like, okay, this person may be a problem officer. So just things for us to flag and keep in mind.
Thank you. And I think with that, let me echo all the positive comments, Jerry, that have been made on the quality of your presentation and those who have worked with you. And in terms of my fellow commissioners' comments, let me also applaud that. It's been very instructive, speaking personally on that one. And I think unless there's anything further on this, we move to autism awareness in blue envelope legislation. Randy, over to you, please.
Thank you, Madam Chair. I will now turn the floor over to legal fellow Victor Lobo so that, as you stated, Attorney Lobo will discuss initiatives and legislation to improve interactions between members of law enforcement and individuals on the autism spectrum. Victor?
Thank you, Randy, and thank you for your time. Good morning, members of the commission, members of the public. As Randy mentioned, my name is Victor, and I am here today to provide you with a brief overview of the recent Blue Envelope program that was just codified into law. With Madam Chair's permission, I will share my screen. Perfect. So we have a bit of an agenda here for today's overview. First, I just want to get into some background of the program. Then I would like to talk about current implementation in Massachusetts, what the situation is on the ground now. Then next steps. So how can we post as a commission support statewide implementation of these new rules? And finally, I took the initiative of gathering some additional resources in case members of the commission or public are interested in learning more. So background, what is a blue envelope? In essence, a blue envelope is a blue envelope. It is literally a tool that alerts a police officer that the driver has autism. By the way, just a quick note, I will be using identity first language today. So autistic driver, autistic person. I am aware of the fact that some people prefer person first language, so person with autism. But based on my research, members of the community, there is grassroots support for that identity first language. So that's what I will be sticking with for consistency's sake. So back to blue envelopes. Like I mentioned, it is a tool that indicates to the police officer that the driver has autism or some other invisible disability. It's a convenience thing. So the driver stores important information such as their license, their vehicle registration, insurance, all the documents that would be needed in a regular police interaction or routine traffic stop, and gives, when prompted, gives it to the police officer. And participation in this program is completely voluntary. Disclosure of one's disability is completely voluntary as well. Now, why do we need blue envelopes? The unfortunate fact is that some certain autistic-related behaviors can be mistaken for deception, aggression, can induce suspicion for when officers that don't have that context. So lack of eye contact, inability to respond to questions or verbal directions, unexpected or rapid movements, all those things, if the officer does not have the context of, hey, this is how an autistic person behaves, that can lead to a tragic misunderstanding. And these misunderstandings can turn routine traffic stops and police interactions into stressful or worse encounters. Now, without this context, both sides lose, so to speak. The drivers fear participating in society and driving around, and the officers, despite acting in good faith, may make mistakes of their own. And so the idea of the Blue Envelope program is that it provides that context, and that's going to be a recurring theme throughout this presentation. Now, the current situation is there is a Blue Envelope program now in Massachusetts. It's a voluntary thing. In 2024, the Massachusetts State Police launched this Blue Envelope. There are current programs in other similar programs in other jurisdictions, and so that's where the MSP was inspired by. Since 2024, more than 12,000 Blue Envelopes were distributed through this proven program. It's proven, it's low cost, it's very effective. It's led to several municipalities even instituting their own equivalent, following the MSP's lead. And this program, in turn, led to the Act that was just recently passed, Chapter 112 of the Acts of 2026. So what does a Blue Envelope look like? I've included here a picture for you. It's Needham's, Needham Police's specific envelope, but the format is pretty much the same. You can see here instructions for the police officer, instructions for the driver, all again in that theme of providing context and ensuring a better communication for all parties involved. So, I want to focus a bit more on those instructions and the contents of the Blue Envelope. First, instructions to police officer, we have common autism-related behaviors to provide that context. There's guidance to help officers communicate with autistic drivers on the envelope. There's the envelope includes the driver's emergency contact information. And there's a QR code for additional resources in case the officer needs more information. On the passenger side as well, there's also tips on the driver's side as well. There's also tips to help prepare autistic drivers for traffic stops and police interactions. Again, ensuring efficient communication between all parties. As I mentioned, there are similar programs in other states. As of today, there are 29 states with some form of Blue Envelope, yellow dots. They're kind of the same thing. Autism indication program, and these happen throughout a variety of means. Some states are they don't have the statutory backing, and so there's a voluntary program, as was the case here in Massachusetts. Some states leave it to the independent local police departments, as is the case in Colorado, and some states have a statutory mandate for such, as will be the case in Massachusetts and is currently the case in Delaware and Connecticut. So speaking of that recent Massachusetts statute, it's Chapter 112 of the Acts of 2026, an act facilitating better interactions between police officers and persons with autism spectrum disorder. It was just recently approved last month in June 25th, and will take effect on September 1st, 2026. It codifies the existing framework of the Blue Envelope program into statute. It requires the MSP to develop and maintain their current program in consultation with key shareholders, such as the Municipal Police Training Committee, autism advocacy groups, the Registry of Motor Vehicles, stakeholders who have an interest in ensuring this program is as effective as possible. Part of the bill is that it mandates these envelopes to be distributed through the Registry of Motor Vehicles. Currently, it's being distributed through the Massachusetts State Police, but one of the bill's focus is to shift that responsibility to the RMV. And the whole theme of the bill is to expand both awareness and availability of the program to the public and to law enforcement. And as I mentioned, I want to talk about, posts role. What can we, as the Peace Officer Standards and Training Commission, do to support this initiative? One recommendation I have is support steps by the Municipal Police Training Committee to incorporate Blue Envelope awareness into existing training materials to make sure that officers, as they get trained, they're aware of this program, right? And they know what to do when handed a Blue Envelope. I also believe we should partner with the Massachusetts Chiefs of Police Association, MCOPA, to share best practices and implementation guidance as this is coming in. Though multiple police departments have instituted their own programs, with the bill's enactment, a lot of police departments are going to be encountering Blue Envelopes for the first time. And so the idea is that we can partner with MCOPA to ensure that these police departments have at least an awareness, proper policies in place to handle those situations. And finally, another good recommendation is that we should improve awareness of the program to law enforcement public through existing disability advocacy organizations. The bill itself was passed with the support of ARC of Massachusetts, Autism Speaks, and a whole range of other very valuable advocacy organizations. And so the idea is we can partner with them and source educational materials and use our role in the law enforcement community to share those educational materials. And as I mentioned, I included some further resources for members of the commission and the public. ARC of Massachusetts, one of the key supporters of the bill. The Lurie Center for Autism at M.G.L has a really good overview of the bill and current program, the current Blue Envelope program. Autism Speaks is another autism advocacy group. And finally, the Blue Envelope program as it exists right now is available, an overview of it as it exists right now is available on the Massachusetts State Police's website. Now, thank you for your time. With Madam Chair's permission, I'm happy to answer any questions. Yes, Commissioner Cahill.
Great presentation. I think this is important. In addition to partnering with autism agencies that provide assistance, I was thinking, has the thought occurred that maybe we should do like a public social media blitz about this program or a commercial? Because I know families that have children with autism that don't necessarily go to an agency to get assistance because they just deal with it. So they may miss this totally if it's only coming from agencies.
Of course, no, that's an excellent question. And that's actually going to be our next step internally. The next thing where Post is working on is spreading information of this program. So we're going to we're going to include information of this program on Post's website. But also, since we one of the ideas is to partner with those disability advocate groups, I imagine that, for example, your friends with autistic children, they're more aware of the advocacy groups than we may be. And so if the information isn't coming from the agencies themselves, it can come from the advocacy groups. So that's something we can encourage.
Right. And do you have any statistics to show how this has been effective in regard to lowering incidents in regard to dealing with people with autism? Does that information exist?
Unfortunately, given the fact that implementation of such programs is it is different in pretty much every state. I don't have access to current information, those current statistics. But what I can tell you is since 2020, when it was started in Connecticut, it's spread to 29 states now. And it's actually been so successful that there are concurrent bills in Congress, both in the House and the Senate, with the purpose of encouraging, of establishing DOJ grants to help establish and maintain such programs.
Okay, thank you.
Commissioner Crispin.
Yes, good morning, and thank you for the presentation, Victor. Just wanted to ask, is there a possibility of teaming up with MPTC to put this in as part of their curriculum for the next upcoming year?
I do not have, that's certainly something I personally believe would be a good, a good measure. But given the fact that this was just passed now, I can't really say what POSIS next steps will be. These are just the recommendations based on my current research. But I believe Enrique has more information on this.
Yes, thank you, Victor. And the answer is yes, Commissioner Crispin. We have open dialogue with the MPTC, as you know. I believe they're in service training for the current year, TY 27 is already deployed. So we could explore opportunities to do something more timely rather than wait until the next TY year. And we can try to figure things out, maybe more outreach and awareness rather than requirement at this point. But yes, there's certainly we believe, given the passage of the law and the support that it has from a number of stakeholders, that this is an important thing to deploy statewide as soon as possible.
Thank you, Rick.
Victor, thank you very much for your presentation. And if you can just stop the screen sharing now.
Of course. Thank you for your time.
I don't think there were any other questions, but I know I speak for the other commissioners, Victor, in telling you how much we appreciated the information that you provided. And I think with that, let me indicate that there are no matters not anticipated by me at the time of posting. So at this point, I would entertain a motion to go into executive session in accordance with General Laws, Chapter 30A, Section 21A1, to discuss the discipline or the dismissal of or the complaints or charges brought against a public officer, employee, or an individual under the same statute, Section 21A5, to discuss the investigation of charges of criminal misconduct, or under Section 21A7, combined with General Laws, Chapter 6E, Section 8C2, and to the extent that they may be applicable, General Laws, Chapter 6, Sections 168 and 178, to discuss matters relating to preliminary inquiries and initial staff review concerning whether to initiate such inquiries and regarding certain criminal record information, and under the same statutes, Section 21A7, combined with General Laws, Chapter 30A, Sections 22F and G, to discuss and to approve prior executive session minutes. Specifically, in executive session, we will be addressing Division of Standards reports of preliminary inquiries in 7 cases, standards request to enter voluntary decertification, suspension, or disposition agreements in 2 cases, an update on 1 matter, and a standards request for approval to conduct preliminary inquiries and or impose a suspension in 7 cases. We will also be addressing the application for voluntary relinquishment of certification with regard to Eric Wade, formerly of the Canton Police Department, and approval of the minutes of the prior executive session. Is there such a motion?
So moved.
Is there a second?
I'll second.
Thank you. Commissioner Baker?
Yes.
Commissioner Calderon?
Yes.
Commissioner Crispin?
Yes.
Commissioner Hall?
Yes.
Commissioner Casarosian?
Yes.
Commissioner Luma?
Yes.
Commissioner Talley?
Yes.
With that, we will now go into executive session. Members of the public, we're grateful for your attendance. Enrique, do you want to again remind them as to if they want to communicate with Post, how they could do that?
Thank you. Just write us an email at postc-comments@mass.gov or visit our website at mapostcommission.gov.
Thank you. Members of the public, we will not be returning to the public meeting after the executive session. Again, I want to thank all the members of Post who have contributed in any way to the presentations that have been made today. I know that my fellow commissioners and I are very grateful for the information that you provided to us. We will take a 5-minute recess before we go into executive session. And I think the Zoom information for executive session has been republished, right, Jamie?
Correct. It's been
Thank you.
resent. Yes.
Thank you very much.
Thank you.